Thank you very much, Marcus, and thank you to the Academy and the University and to Director Rakvitz for this invitation. It is really great to be able to participate in this conference. And I would say that in this panel, we're going to hear from three cousins, the national prosecutions, international prosecutions, and the human rights courts. And I must say that the reason I'm so excited to be here is because the international prosecutions, at least ICC, were definitely the younger of these cousins, and perhaps don't have the coolest toys of the three, but we certainly have much to learn from the others. So thank you, really. And I hope that this last panel is going to be as interesting as the previous one was. So we are going to be discussing the ways in which different judicial institutions have sought redress for enforced disappearances at the national, international levels, and in the regional courts. And because our two panelists, Andreas and Dilek, are going to focus mainly on the experiences at the national level and in the regional human rights courts, I'm going to spend some minutes taking a brief look at the work of the international criminal courts, and I will specifically make some remarks on the extraordinary chambers in the courts of Cambodia, the ECHR, the Kosovo specialist chambers, and the ICC. And so the first thing to point out about these three is that I think the facts are probably known to everybody, but they deal with facts in three different periods. The Cambodia cases are from the mid to late 70s. The Kosovo specialist chambers deal with crimes committed in 1998 and 1999. And the Rome Statute, of course, can have a much longer temporal jurisdiction. But so far, the issue of enforced disappearances has arisen in a limited number of situations. It has most recently arisen in the situation in Burundi, and the facts relevant to that investigation are the disappearance of persons in the context of political repression in pre-electoral and post-electoral, in a pre-electoral and post-electoral setting in 2015 to 2017. We have also, sorry, I should say that is the situation for which we have a judicial pronouncement already, because the pretrial chamber in 2017 issued a decision under Article 15 of the Rome Statute authorizing the prosecution to open the investigation into a situation in Burundi for crimes that included enforced disappearance. In addition to that, the Office of the Prosecutor, as many people know, conducts preliminary examinations into many other situations, and this is the stage prior to the investigation commencing, and which we are just monitoring violations that might amount to crimes within jurisdiction of the court in all of our states parties. And among those, enforced disappearances have come up, particularly in Guinea and in Crimea, but neither one of those has really reached the investigation phase. For Crimea, for Ukraine, the office recently said that we believe that we can proceed, that the criteria are met to proceed, but there are no judicial proceedings yet to speak of. So I will be focusing really on Burundi. And so what I can say about the legal framework of these three different courts is that they have actually a lot in common. The Kosovo Specialist Chambers law mirrors very closely, not exactly, but very closely the Rome Statute. So those two are kind of very similar, with the exception that the Kosovo Specialist Chambers law draws the elements of the enforced disappearance from customary law. And the ICC, of course, has those elements already listed in the statute, as well as in the elements of crimes. But they're pretty similar. The ECCC is also similar in a way, because when the trial chamber looked at the crime of enforced disappearance, it also turned to the elements as they stand in customary, as they stood under customary international law in 1975. But the main difference with the ECCC is that they did not prosecute the crime of enforced disappearance as a self-standing, as an enumerated crime against humanity, but rather they had to read it as an example of another crime against humanity, which is other inhumane acts. And they did, the trial chamber in the ECCC did refer to the elements of enforced disappearance, but there was a bit of a back and forth with the ECCC's appeals chamber, the Supreme Court chamber, which said that the trial chambers having looked or relied on the elements of enforced disappearance was anachronistic and legally incorrect because enforced disappearance had not crystallized into customary international law in 1975, and that rather the trial chamber should have focused on analyzing whether, in light of the circumstances of the case, the relevant conduct met the criteria to amount to the crime against humanity of other inhumane acts. But otherwise, the definitions are similar. I'm going to talk a little bit about the ways in which they are different. So the material elements, the main ones, are present in all three courts. So there's first the deprivation of liberty, and then the refusal to disclose information regarding the fate or the whereabouts of the person, or to acknowledge the deprivation of liberty. And in all three courts, the crime must be perpetrated by state agents or with the authorization, support, or acquiescence of state agents or of a political organization. One difference is that in the Rome Statute, in the elements of crimes, acquiescence only applies for a scenario of detention, but not for the, for the element of detention, but not for the element of the denial, as it were. It was some of the challenges posed by the definition of enforced disappearances that the ICC has to work with were already pointed out very eloquently yesterday in Professor de Fouville's keynote address. And so one of them is that whereas in the definition that the ECCC and the Kosovo Specialist Chambers work with, the removal from the protection of the law is a consequence of the act. Under the Rome Statute, it is part of the mens rea. So although there is some language in the Burundi Article 15 decision of the ICC describing the removal from protection of the law as a consequence, and that's in paragraph 120 of the decision, the chamber says, as a result of the enforced disappearance, the victim is removed from protection of the law. The reality is that, and as a pretrial chamber also noted in that Burundi decision, Article 7.2i of the Rome Statute and the elements of the crime refer to the perpetrator or having to have had intended to remove the person from the protection of the law for a prolonged period of time. So there's nothing we can do. It's there, and we must live with it until and if there is the amendment that has been proposed yesterday. There's also a difference between the ICC definition and the Kosovo Specialist Chambers definition, where the mental element is concerned, because the Kosovo Specialist Chambers decision, and that was a decision of October of last year, confirming an indictment against Tachi and others, pointed out very explicitly that under customary international law applicable at the time, there is no need to demonstrate or even presume the special intention of the perpetrator to remove the victim from the protection of the law. So that's really the hardest bit of the definition that we have to work with at the ICC. I want to suggest, however, that although the definition that we work with at the SEC is more burdensome undoubtedly, it doesn't preclude successfully prosecuting enforced disappearances, in particular where there is strong evidence of intent. And of course, as the pretrial chamber said in the Article 15 decision, intent can be inferred from the manner in which detention was carried out. And I also want to say that yesterday, Professor Fabile also raised the concern that about the, for example, that records of the arrest could be altered. So I think, yes, it's true that sometimes we will find very little evidence, very little information about the refusal to provide information or to acknowledge the detention. But on the other hand, this is part of the work we do as prosecutors. We also have to try to find direct evidence of intent of the perpetrators, for example, by speaking to insider witnesses who can describe the internal working and decision-making of the relevant organizations. And this is not unique to the investigation of enforced disappearances. It's a necessity in practically all of our cases at the international level, in which we are typically collecting evidence on a range of crimes, and rather than just on a single isolated crime against a single victim. But I also wanted to offer a thought about, well, if the definition of enforced disappearance in the Rome Statute proves to be too difficult, if we just cannot work with it, are there other options? Could we perhaps use a different provision of the Rome Statute to address a crime? It's not the preferred approach. I'm not promoting it or saying that it would be the panacea, but I'm just thinking, if we're not just going to sit on our hands, we've got to think also what other possibilities there are. And so I think the question arises whether the ICC could adopt or follow the approach followed at the ECCC and prosecute enforced disappearances as a crime against humanity of other inhumane acts. And that crime against humanity has two main elements. The first one is the infliction of great suffering or serious injury to body or mental or physical health by means of an inhumane act. And the second element is that the act has to be of a similar character, that is, of a similar nature and gravity of any of the other acts expressly listed in the Crimes Against Humanity provision in Article 7(1) of the statute. And there are war crimes that are similar. They're not exactly the same. In particular, the contextual element obviously is different, but we can think of the war crimes of inhuman treatment, willful causing of great suffering, and cruel treatment in Articles 8.2a(2)(2), 8.2a(3), and 8.2c of the statute. Could those perhaps be suitable alternatives? I think it would depend on the circumstances of the case and on the evidence available, but it's something to consider. And I think that we would need to ask three specific questions to kind of decide whether any of these could be suitable alternatives. And in particular, the crime against humanity of other inhumane acts. And the first question is whether it's legally plausible to charge and enforce disappearance as a different crime against humanity. Our chambers at the SEC have said that a chamber can convict cumulatively for the same conduct if each statutory provision has a materially distinct element not contained in the other. That is an element which requires proof of a fact not required by the other provision. And in applying this test, it's the legal elements of the crime that we must look at and not the acts or omissions of the accused. So if the offenses are not materially, and if the offenses are not materially distinct, only a conviction under the more specific provision can be entered. So one potential obstacle to dealing with an enforced disappearance in this way as a crime against humanity of other inhuman acts is the case law at the ICC indicating that one cannot charge conduct as an other inhumane act if it is captured by one of the other enumerated crimes against humanity. And this has been addressed in the confirmation of charges decisions in the Katanga case and in the Mutaura case, and most recently in the Ongwen trial judgment in paragraph 2745. And what the trial chamber said in Ongwen is that if the act is of the same nature, if the harm suffered is the same, and the protected interests are the same as the other enumerated act, then you could not charge under other inhumane as an other inhumane act. So difficult, but I think it's the legal plausibility of charging an enforced disappearance as an other inhumane act is something that we would have to look at in the circumstances of a specific case. In addition to that question of the legal plausibility of charging in this way, there are, of course, other questions. One is, would doing so, would charging the conduct in that way permit representing the pattern of victimization properly? And again, we would need to see what the specific facts are. But I wanted just to point out that, in a way, that is precisely what happened at the ECCC. The ECCC entered convictions for the crime against humanity of other inhumane acts. But if you look at some of the specific findings that they entered, I think they probably represented the reality of what the victims suffered. They entered findings about detentions. They found that persons had been deprived of their liberty, that these disappearances were widespread. They entered findings with respect to the denial. There's one example in the judgment about one of the district secretaries, one of the local authorities, who was approached by families who were looking for their dear ones, but this was contrasted with the case of another district secretary who people would not approach because they were very scared to do it. And what the trial chamber said is that it concluded from this reality was that there was a total absence of any lawful process whereby persons could properly seek and obtain information about the fate of their relatives, because at the most, the district secretary could choose to provide information or to take steps, but it was not a measure that was generally available. And that this climate amounted to a generalized refusal to provide information about the fate of disappeared persons. So these are all findings that you would recognize from a decision on enforced disappearances, and yet they're findings contained within a decision on other inhumane acts. And in addition to these findings that are very specific to, or that correlate very directly to a definition of enforced disappearances, the ECCC trial chamber also made the findings necessary for other inhumane acts about the detentions and denials of disappearances having caused serious mental or physical suffering to those left behind without any further information as to their fate. It also concluded that the disappearances were of a nature and gravity similar to other enumerated crimes against humanity. So I think it's worth some thought. Finally, of course, a question one would have to ask is whether, charging enforced disappearances in this way, if it's necessary to do it, if it's the only option, would be satisfactory to victims. And with that, I'll leave it. I'm going to give the floor now to Andreas Schcher. Please, Andreas.
Yeah, thank you very much, Julieta, and also thank you very much for the invitation to speak here. I mean, I would love to be in Nuremberg at the moment, and with all of you, and not speaking from home, but so be it. And thank you very much for putting this excellent conference together. I will briefly speak about a number of situations which concern more the national prosecution level, partly under universal jurisdiction, partly not under universal jurisdiction. So, as already mentioned by Markus Krajewski, certainly the Syria cases under universal jurisdiction are relevant here. So I will address those, but also briefly look into other situations and cases such as on Latin American dictatorships, and also, if time allows, on Sri Lanka. But moreover, I will also speak about discrepancies between legal obligations to prosecute, the German government positions on fulfilling this duty, and the reality in those cases just mentioned. And I think, especially as Germany is applauded to stand up for human rights prosecutions, and rightly so, I think it's also quite important to look into how Germany deals with the enforced disappearance topic. And obviously, I've chosen Germany as we at ECHR litigate and work a lot in Germany, and as we were all supposed to be together in Germany today. So let me start with, I think that there are only very few prosecutions globally of enforced disappearances, and you might ask yourself why, and it has been already discussed in the previous panels quite a bit. I think the ongoing impunity, the huge problem of impunity, and the non-enforcement of the convention, but also of criminal law in the context of enforced disappearances. So that's something, that's the reality, that at the moment there are only very few prosecutions, and some reasons have been named already for that. And on the other hand, I think it's quite important also to stress, also from our experiences at ECHR, working with survivors, working with relatives of disappeared persons. Some disappeared in the last years, some already decades ago. It's the crime that has a huge impact on victims and on relatives and families for decades, and that makes it also so heinous, and that's why it's a separate crime. And I think that's also important to remember, and I will also come back to that. Looking into the Syria cases, in July 2020, Germany issued another state report to the UN Committee on Enforced Disappearances, saying, for example, that enforced disappearances are sufficiently addressed in prosecutions in Germany, and highlighting the so-called Al-Khatib trial at the moment going on in Koblenz, where two former Syrian regime members are standing trial since April last year. And the German government says in its report that basically what's on trial there covers what's meant under the convention as enforced disappearance. And on the first glance, that seems natural, given the fact that, like according to the Syrian Network for Human Rights, more than 100,000 people are missing and disappeared in Syria, so a huge number. And if you then have the first trial on Syrian regime members or former regime members, you would also think that this crime of enforced disappearances is prosecuted there. But if you look into the indictment of the in the Al-Khatib trial in Koblenz, you will see that deprivation of liberty is charged, torture, killings, and lately also sexual and gender-based violence and crimes were added to the charges as crimes against humanity. But you will see that enforced disappearances under the German Code of Crimes Against International Law are not charged. But that's exactly what Germany references to the UN committee, that this is the trial where as a good example that enforced disappearances are being prosecuted. But exactly the charge of enforced disappearances is not in the indictment. So that shows basically that the concept, the meaning, and the importance, and also the history of the crime of enforced disappearances is not really well understood or even ignored. And I think this conference again sheds some important light on why it's a separate crime, why there is this convention, why there is a difference between abduction and forced disappearance, for example. And those charges then also need to be prosecuted because they address different crimes, they protect also different goods, and they have a different impact on society. So that's why it's so important to prosecute them and not to prosecute abduction or torture or other crimes instead. And also to include from the first moment in an investigatory strategy already the crime of enforced disappearances, because you need to investigate it from early on to be able also to prosecute it at a later stage. So why is the crime against humanity of enforced disappearances, as you find it in the German Code of Crimes under International Law under paragraph 7, number 7, not charged in the trial in Koblenz against the 2 Syrian former regime members? I think first we have to see that in the law, in the German law, there are 2 variations of criminal conduct. So the first one is for the perpetrator of the abduction, basically, and deprivation of liberty. And the other one is of a perpetrator refusing basically to give information about the fate and the whereabouts. And for the latter, perpetrator needs to reject the information as part of a legal duty the perpetrator has. But also for the first version here, the perpetrator of the abduction, it's needed that there's a failure to give truthful information as part of the elements of crimes here. And here, it doesn't have to be the same person, basically, who refuses to give the information, who is the perpetrator of the abduction. It can also be by another state official or relevant person here. But the problem here lies also in the question if a family member doesn't formally ask, and thus there's simply no communication by the state about the fate or whereabouts to family members or to anyone else, basically then you have no crime. And the other question is also the failure to give truthful information. Does it have to be also legal duty here? Is there any official communication needed? Which activity by a relative is sufficient in approaching authorities to receive information? Does it have to be the kind of a formal request to a police station or secret service? Whom do you need to ask in writing? And I think most importantly, the question is, in a situation such as in Syria, what if it's simply too dangerous to ask, to go to the next police station, to go to the Secret Service branch to ask about the whereabouts of one of your relatives? So the question here is basically what's needed from the relatives. Can they ask through a friend of a friend or through some not so close relatives who might have some connection to the state apparatus to receive some information? Is that sufficient to fulfill the element of crime, that there's also failure to give truthful information through those panels, or does it need to be official with official documentation and all of that? Of course, at ECHR and in supporting and representing civil parties and survivors in this case, we think it must be absolutely sufficient under the given circumstances of repression and conflict in Syria, that there's whichever form of request by a family about the whereabouts or fate of relatives as sufficient to fulfill basically the crime of enforced disappearances. Because the criminal behavior here combines the abduction and the rejecting the information about abducted persons, first not allowing them to communicate outside, but on the other hand also not the outside to get to know about the fate. So the lack of information is certainly crucial here, but on the other hand, if there's a general situation in a country where it's hardly possible to ask, the question is how you weight that in criminal law. And nevertheless, of course, in Syria, there were also quite a number of families and relatives that were asking, that made inquiries directly or indirectly. So if you investigate that from the very beginning, if you question witnesses into that direction, you will also get the evidence you need to charge the crime of enforced disappearances as a separate crime. So again, there's a big lack and a gap in the indictment, in inculpance, and in the investigation when it comes to enforced disappearances. The German government is reporting otherwise, but again, I think it shows here that there needs to be a much stronger focus on the crime of enforced disappearances as a crime against humanity here. And it's also still not too late to still include it in the trial and in the charges as it's still ongoing. From here, maybe also moving briefly again to the German government's position with regards to enforced disappearances, and that they are also covered by other crimes. It's something we've heard also in the past, especially when it comes to the discussion whether there should be also an ordinary crime of enforced disappearances outside the context of a crime against humanity. For example, in the German Code of Crime, the regular Code of Crime. And there are a number of cases of German perpetrators who were part of the commission of crimes of enforced disappearances in Chile and Argentina that are living in Germany again with German passports, can't be extradited and thus can't be prosecuted in Chile and Argentina directly. So it's the duty of Germany to prosecute those. And that's not possible at the moment, or only under the charge of murder, which is the only one which is not statute barred after now 30 or 40 years of the fact. But they cannot be charged with enforced disappearances, first because at the time the crime didn't exist under German law, and similar crimes like abduction are already statute barred because it's too long ago. And murder, of course, you need to prove it, and you need different evidence, which also often makes prosecutions not easier, as in a lot of disappearance cases. The person remains disappeared until today. So there are some problems here to prosecute those old cases in Germany, which leaves an impunity gap because at the same time perpetrators are not extradited to Chile or Argentina because they have German citizenship, and Germany doesn't extradite its own citizens. So there was the request by the Committee on Enforced Disappearances to Germany to amend also the criminal code accordingly, because of course there are also in the future there could be situations where a perpetrator of an enforced disappearance outside crime against humanity, so more individual cases, comes to Germany, enters Germany, and cannot be prosecuted because for other crimes under German law, such as abductions, it might be too late already, or there is also no kind of universal jurisdiction. So that's another ongoing issue that in Germany the prosecution is only partly possible in those situations, which is another gap in the law we see, and which also avoids potential prosecutions in the future. And let me close with another case, which I think is also kind of emblematic to see how globally or also from a European perspective, it's quite difficult to prosecute enforced disappearance cases. It's a case on Sri Lanka, where in the conflict in 2009, many people disappeared, where important witnesses and evidence is in Germany and in Europe, but still not secured by authorities here to build cases. And hopefully the new ECHR mandate also improves this situation. For example, there were cases like the case of Father Francis, who accompanied a group of former LTTE cadres surrendering at the very last day of the conflict. They were crossing to the government or Sri Lankan armed forces controlled area. Daytime locations are known. Witnesses, as I said, are accessible. We know to which division they surrendered. The commander of the division is known. They were seen in buses of armed forces being driven away. And since then, there are no signs about their whereabouts, nor of the former LTTE members, nor of Father Francis, who basically negotiated the surrender with the Sri Lankan armed forces. But again, I think it's a quite emblematic case. There's a lot of evidence also outside Sri Lanka accessible, but you don't have any form of international prosecution so far on this issue. And moreover, the commander of the said division served for 5 years as Sri Lanka's deputy permanent representative to the United Nations in New York and worked completely free. So these are, I think, examples where enforced disappearances, you need an international effort basically to prosecute those cases, a collaboration among war crimes units and states when evidence is spread all over, but also the political will basically to start those cases, to collaborate and bring those cases forward. So these were a few examples from our work at ECHR with regard to enforced disappearances. There's much more to say, obviously, but yeah, thank you very much, and I'll stop here.
Thanks very much, Andreas. And let's now hear from Dilek.
Thank you, Julieta, and I also would like to thank the organizers very much for their invitation. It's really a pleasure to be here with you. Also sorry that we're not able to meet in Nuremberg. I have a PowerPoint presentation, so I'm going to open that now. What I'm going to speak about really is, I'll be focusing on the European Court of Human Rights. So this is about human rights. It's not, it's not about international criminal law or domestic criminal law. I'll be focusing on the European Court of Human Rights as jurisprudence, but withdrawing some with some comparative insights from the InterAmerican system, which I'm now working on in my next research project, which I've started to really look into very briefly. I just want to say actually how fascinated I am with Andreas's presentation that the German government has, how to say that, misrepresented the domestic criminal, the case and their domestic criminal code. I find it very interesting. But so what I'm going to do is really, I'll speak a little bit about, first about procedural issues, admissions of evidence, standard of proof, burden of proof. Then I'll discuss substantive issues, a little bit on the definition of enforced disappearance, and then what rights are implicated under the jurisprudence of these courts. But I will only discuss two rights, really, the right to life and the prohibition of torture. I'm not going to get into other rights because there's not enough time. And then in the end, I'd like to reflect on what we should understand from effective supranational judicial oversight should be when it comes to enforced disappearances and actually gross human rights violations in general. So maybe to start with what type of evidence is admissible. Both courts have actually quite wide powers in terms of what kind of evidence they may seek, request, and then use. It's basically any evidence, and then they can also hear witnesses and experts. And when you look at the jurisprudence of the Inter-American Court of Human Rights, you see that the court has been interpreting its powers quite liberally and expensively, and also exercising them in such way. The court, from the very first judgment, the Velázquez-Rodriguez versus Honduras in 1988, its first judgment ever, which happened to be a case on enforced disappearances, has been really explicit in its openness to indirect evidence, including circumstantial evidence. And doing that, justifying that, the court has emphasized the difference between domestic and supranational courts and criminal and human rights cases. As a supranational court, it's not in a position to access evidence, direct evidence directly, and that it is because it's a human rights court. It's victim oriented. It doesn't seek to punish perpetrators. And the court especially said how important such evidence is, indirect evidence is, especially in enforced disappearance cases. And for example, when it comes to press reports, just to give an example, the court sometimes use it as documentary evidence, especially if the news reports contained statements of government leaders, but at other times to corroborate witness testimonies. When we look at the ECHR, again, similar wide powers, but this court has been very restricted in its and very restrained, really, in its interpretation exercise of these powers. The court insisted on, the ECHR has early on insisted on direct evidence in enforced disappearance cases, and I'm talking now about its early jurisprudence on Turkey, because the court's jurisprudence on enforced disappearances started with Kurdish cases against Turkey, then came Russia, and then building on this jurisprudence, the court further developed its case law on the Chechen conflict and then other North Caucasus later. So it's actually quite remarkable that the court required victims' families to produce direct evidence of custody, and this against the backdrop of categorical government denial that there was ever a detention or disappearance, and also government non-cooperation. Turkey was very adamant in not cooperating with the ECHR in producing, the sharing the information in its exclusive possession. And the court found eyewitness testimony of abduction or custody insufficient. And this was also the case in torture cases. Applicant statement was found to be insufficient even when substantiated with a medical report. This is a 2000 judgment. Now then the question is, if there's no direct evidence, in the absence of evidence, who bears the burden of proof? Again, starting with the Inter-American Court, the Inter-American Court's approach in general was very clear from the first case judgment onwards. The court basically started from the general picture, looking at the political context in general, and they're moving from that to the individual. So again, in Velázquez-Rodriguez, the court basically said, it's a two-pronged test, really. The victim first has to show whether there's an official practice of disappearance, right? It doesn't have to be carried out by the government. If it's tolerated by the government, that's also sufficient. And again, doing that, let's remember, victims could use indirect evidence, circumstantial evidence, right? Media reports, human rights, NGOs reports, UN reports, etc. And then link this particular case to that pattern, right? Does the disappearance of this particular individual fit that pattern? If yes, then there's a presumption of death, that the individual, the disappeared has actually died, and then the burden shifts on the government. Coming to the ECHR, again, initially, first Kurdish cases, again, initially the court required direct evidence, as I said earlier, also for presumption of death, right? That applicants had to actually produce evidence that the individual was detained by the state, and did not shift the burden even when the court itself found procedural violations of Article 38, for example, in the government's non-disclosure of documents that were critical, and that were in its exclusive possession. And there were, I have to also add here, there were internal protests. Judge Bonello, just to, he kept protesting against this, and also against other issues that I'll come to. Then there's a jurisprudential shift in 2005, and then it was only in 2005 that the ECHR started to shift the burden to the government because of its non-disclosure of critical information. And then the court said, when the applicant makes a prima facie case of state control prior to disappearance, then the burden shifts, right? So the new test, and also for torture cases, was when the government fails to fulfill its procedural obligations, then there's presumption of death, the burden shifts. But of course, applicants were still required to prove state control, which was of course very difficult to do that. When it comes to Chechen cases, we see that the learning curve perhaps was now at work, and the court became more flexible on this. Initially, the elements of prima facie case were laid out as, there were 4 elements. This is a 2006 judgment against Russia, that the government must not deny the detentions. Witness testimony, there has to be witness testimony that the detention occurred in life-threatening circumstances. No news from the person since the detention, and the government cannot submit a plausible explanation. Obviously, the first 2 were extremely difficult, if not impossible, to meet. And over time, the court effectively removed the first element. So even if the government denied, that didn't matter. And witness testimony that abductors can only be state servicemen were started to be accepted. For example, that the individual was abducted by a large group of armed men in uniforms who were able to move freely through federal checkpoints at night. So in sum, the ECHR's jurisprudence on enforced disappearances was basically a case-by-case approach, right? The court, the ECHR, never went to Inter-American, although the victims and their lawyers, families and their lawyers, asked the court to follow the lead of the Inter-American Court of Human Rights and find a state practice, and then see whether this particular case fitted. The ECHR was adamant in finding administrative practice of enforced disappearance, but also of torture, extrajudicial executions, and forced displacement in the Turkish cases. And did that so despite fact-finding reports produced by UN and Council of Europe's non-judicial bodies, including the working group, right? The applicants would submit to the court these reports showing that there was a practice, for example, torture was systematic in Turkey, that there was a practice of enforced disappearances. At best, the court, you see, referring to phenomena of internal displacement, enforced disappearance. And when it comes to disappearance in Turkey, even this was very late. In 2012 only, the court actually said that there's a pattern of disappearance. But even when it said that, it never said that there's a practice, a government policy of enforcement disappearances. Standard of proof, again, the Inter-American Court of Human Rights, as I said earlier, emphasized the difference between criminal justice and human rights law, and said, we need to adopt a standard of proof that really takes into account how serious enforced disappearance is as a crime, and is also capable of establishing the truth. The court later called this reasoned judgment. Basically, the court gave itself the authority to exercise reason, really, and to engage in a logical analysis in a way, and that's enabled to make presumptions, for example, of death, right? When it came to the European Court of Human Rights, the ECHR has been extremely stringent in the standard of proof, which is a beyond reasonable doubt standard, which is used in criminal cases. And the court expected applicants to prove their allegations beyond reasonable doubt. Again, there were internal protests, again by Judge Bonello, but also in a case against Italy, in a Grand Chamber ruling, 8 of the judges actually of the 17 dissented on this issue and said this is an inadequate, possibly illogical, and even unworkable standard. Over time, the court said this is this has an autonomous meaning, but really never clarified what it actually means by beyond reasonable doubt, and it remains, in my opinion, quite ambiguous. Now, on substance, a little bit definitional issues. The Inter-American Court of Human Rights has always approached enforced disappearance as a multiple and continuous violation of rights. I mean, this was mentioned earlier also yesterday. Starts from the deprivation of liberty, continues until the establishment of the fate and whereabouts, right? It's continuous and it's multiple. And it is an autonomous offense. That there is an offense of enforced disappearance, and also that it is a crimes against humanity, like torture. And the Inter-American Court of Human Rights has also said that prohibition of enforced disappearance and the duty to investigate and punish are also jus cogens norms arising, imposing erga omnes obligations on member states. Whereas the ECHR has always had a very piecemeal approach, assessing implicating rights separately, but never really discussing what the definition is, whether it's an autonomous right, or certainly whether it's a crime against humanity or not. In terms of implicated rights, the Inter-American Court of Human Rights, as I said, I'll only speak about right to life and prohibition of torture. The court was basically, again, from the first judgment, the Inter-American Court said this is a flagrant violation of the right to life, right? Ipso facto, basically, because it often involves secret execution without trial and the concealment of the body. In terms of prohibition of ill treatment and torture, this concerns, of course, two issues, right? The victim and the families. In terms of the victim or victims, the Inter-American Court of Human Rights presumed cruel and ill treatment of victims before they were disappeared or murdered, because that's how enforced disappearance works in a way. But only if there was a prolonged isolation. In cases where victim was murdered soon after he or she was disappeared, then the court did not find torture in relation to the victim. And in terms of the family members, the court concluded that they suffered ill treatment throughout this process. When you look at the European Court of Human Rights, initially, again, in the Kurdish cases, because it started with the Kurdish cases, the court was extremely restrained. Infamous Kurt case, the court did not find a right to violation there and addressed this as a deprivation of liberty issue. Then there's a shift, this jurisprudential shift that I mentioned earlier. So the court starts speaking about life-threatening tests, right? It said, in the general context of the situation in Southeast Turkey, although never really elaborated what that general context is, the court concluded that an unacknowledged detention would be life-threatening, right? And if there's sufficient time has lapsed, if state control has been established, government motive has been proven, then there's presumption of death. This changed in Chechen cases, I'll come to that. What's really interesting, I'd like to mention these two judgments. At some point what happens when state's responsibility is not established, right? When applicants cannot establish that actually the state has responsibility in the disappearance. Then the court introduced these positive obligations tests and basically said, when authorities knew or ought to have known of a real and immediate risk to the life of an individual, then they should have taken preventive operational measures as soon as they knew that the person was disappeared in order to save their lives. I'll come to this in my final comments, why I find this to be a very problematic approach, although this has been, when you look at the literature, it's really acclaimed as a very innovative approach. And in the Chechen cases, the court over time basically said, state control is established when abductions occurred during security operations, these sweeping operations, or on the basis of free movement through checkpoints, right? When the abductors were freely able to move through checkpoints, then state control is established. Eyewitnesses are still essential, but not enough. Again, applicants had to show free movement through checkpoints. And in terms of torture and ill treatment for the ECHR, the court said from the beginning that, from the first judgment really, that enforced disappearance constitutes ill treatment in relation to family members. But when it came to victims themselves, the court did not find that, unless there were eyewitnesses of ill treatment during the abduction, if there were eyewitnesses showing that the person was beaten while being abducted, or ill treatment under custody was established by domestic courts, in which case it could also conclude torture. Otherwise, for the ECHR, it is an ill treatment of family members subject to limitations that I have here, certain family members who have particular circumstances, but not the victim itself. I have 3 minutes left, and now I'd like to have some concluding thoughts. And these concluding thoughts are really based on my research on the Kurdish cases, because my book is about the ECHR and Turkey's Kurdish conflict, and I know, and I'm also from Turkey originally, And I know the political context there, I know the legal context. I'm saying all of this because I think it's really extremely important to know the context, to be cognizant of the context in interpreting the jurisprudence of the ECHR. Now, first of all, what the Kurdish cases show is that this case-by-case approach is really futile. The court, like the Inter-American Court of Human Rights, that when you're talking about gross violations, state violence, especially against minorities, courts have to have a contextualized approach. They have to bear in mind the context. I mentioned the positive obligations test earlier. You know, what the court did there was basically, it was an escape strategy, right? Because it did not want to go down the Inter-American Court path of finding an admissible practice and then saying, okay, it fits. This is how things happen in Turkey, and this person was abducted in such and such way. Therefore, there's a right to life violation. So it wanted to stick to its life-threatening test approach, but because state responsibility was not established, then the court came up with positive obligations. Now, positive obligations may make sense in the case of Osman versus United Kingdom, which is where this was developed, where somebody who's in prison dies. Okay, then you can say, yes, the state has responsibility, should have prevented, taken operational measures. But in this case, enforced disappearance was a state policy. It was done by the Turkish military, by Turkish intelligence, by Turkish security forces and their proxies, so either directly or indirectly. So to expect then the state to save the life of person that they know that that has been disappeared is just, I think, really flies in the face of the reality. It's it's the Turkish state that, of course, disappeared these individuals and had them killed. There's a need for a multiple rights approach. And then one thing that I would like to say about effective, two things actually. One is effective remedy. Before in the previous panel, I think it was Luciano who spoke about security sector reform and how this has many of these things in Latin America happen in the context of post-transitional. Now, in Turkey, the moment the EU entered into the picture and the Turkish government adopted reforms to qualify for EU accession, things have changed also for the ECHR. Turkey adopted a reform law, it's called a reform law, to give, which basically gives compensation to victims of gross violations, including enforced disappearances. And the ECHR really rushed in applying its new pilot judgment procedure in 2006 in finding this law to be an effective domestic remedy, and then rejecting 1,500 pending cases, including enforced disappearance cases, and they were all cases concerning gross human rights violations. Although the court itself over and over said that effective remedy for enforced disappearance means not just compensating victims, but also identifying and prosecuting the perpetrators. And this particular piece of legislation in Turkey does not provide that. There's no truth element, there's no investigation element, it's just compensation. And the ECHR went against its own jurisprudence just to ease its own caseload and rejected all these cases. So it's really important for supranational courts to be aware of authoritarian regimes and their playbooks, and that brings me to my concluding thought and argument, is that there's really a need for a differentiated approach when it comes to authoritarian regimes, versus liberal democracies. And supranational courts should treat them differently and apply, when they apply, for example, positive obligations test or the subsidiarity principle, they should be mindful of that. If you're more interested in ECHR and Kurdish cases, this is my book, and I'd like to thank everybody for their attention.
Thanks very much, Dilek, right on time. And now we have time for a little bit of a discussion. We have 15 minutes. I see one question from the floor, but if there are any others, please send them through. The question we have from the floor right now is there any principal difference between the situations of enforced disappearances being committed by state representatives and by actors from so-called quasi-state or self-proclaimed states? I don't know, Andreas, is this something that you could comment on? Is it something that arises in the cases that you were following?
We are mostly looking into state cases, but of course in the Syria context, you also have disappearances by by non-state actors, although to the statistics I used, there were, I think, 85% were state actors. I mean, from the German law and universal jurisdiction perspective, certainly you can prosecute both. So I wouldn't see a big difference there in the Syrian context, but yeah, I also can't go into every detail where there might be some differences when it comes to the proof and the evidence.
Dilek, do you want to say something about this one? From the perspective of the ICC, I mean, it's similar as what Andrea was saying. There's a possibility, I think, because of the inclusion of political organization in the definition of the crime, that both scenarios could be prosecuted. Okay, and so I wanted to ask you, Andreas, also in relation to the cases that you're following, whether the issue of whether the denial must be made knowingly, whether that has arisen. Because I can think of situations where different perpetrators could be people perhaps with the duty to provide information, but they might not be in possession of the facts. They might not actually know about the fate or whereabouts of the person. And I would be interested to know if this has come up, whether there's an expectation that people can only be prosecuted if they have access to the right information and they give false information.
Yeah, thank you very much, Julieta, for the question. I think specifically in the Syria trial context that's going on at the moment, I mean, it depends first and foremost on the prosecutorial strategy, of course, on which crimes and charges you put the focus and which ones you want to prosecute. I mean, there are, of course, examples that if you want to prosecute too much, the trial might be delayed or even collapse or make things difficult. On the other hand, if you only focus on one or two charges and crimes, you miss quite important others that also have been committed and where you also have survivors and that also have a different impact in the end on this context and the society in which those crimes happened. And when it comes to enforced disappearances, I think the step taken and that would need to be confirmed then by German courts, of course, is really the question. You know, what have families, relatives, and so on to do in terms of asking for the whereabouts of a disappeared person, and what does that entail? And again, it would need a prosecutor here to bring those charges and then courts to rule on that. But I think it's also important to look into international jurisprudence on those questions. When it comes to the knowledge, I think there are so many cases, again, in the Syrian context, that you'll always find some where you could even prove that the head of a certain detention center or of a branch of a secret service actually would have certain information available, or at least you can prove that a disappeared person was detained in the detention center, and the person is controlling and commanding, and then still often you would see that either there are death certificates with obviously wrong information of kidney failure or heart attack as the causes of death, or relatives are told they should go to another authority or to a hospital to ask for information there, although there's evidence that the person was in the same detention facility. So, and I think from these not only circumstances, but that you are the head of such a center and you had a person in custody there, I think it would already mean that if you give false information, you would have known better. But again, also the pretrial chamber decision on Burundi with the kind of circumstantial evidence or from the circumstances, you can also refer to the intent is, of course, quite crucial here, which goes also a bit in the Lex direction. I think that if you look what happened in Turkey in the 1990s, for example, that even if you don't know each and every detail, but you know the basic circumstances, that it's clear in which context you're acting, and I think that's an important part to prove and also here to contextualize in which how this crime is happening, especially the crime of enforced disappearances, which is a kind of a contextual crime, as it has quite a number of different elements.
Thank you, Andreas. And Dilek, I wanted to ask you in particular, because the ICC, it has to apply and interpret the statute in a way that is consistent with internationally recognized human rights. And the way it works in practice is that for certain concepts that are embedded in our statute, but which are not defined in our statute, it would be natural and appropriate for the ICC chambers to turn to the jurisprudence of the international human rights regional courts. And I think one concept where I see as a very clear candidate, is the concept of fate or whereabouts. It's included in our definition, of course, but it's not defined. So I wonder if you could talk a little bit about whether there's an evolution and how that concept of fate or whereabouts has been understood in the regional human rights courts, what you think the trend is in terms of whether the terms ought to be read narrowly or in an expansive sense.
It's when you look at the ECHR's jurisprudence, it actually, that formulation doesn't appear. There's in terms of the fate and whereabouts. What the court says, it's over and over. I mean, and the court's judgments are quite actually similar. I mean, oftentimes the court repeats itself, right? There's like these standard sentences that keeps repeating. And what one concerns effective remedy under Article 13 of the European Convention that I mentioned earlier. So there, the court says, effective remedy means not just compensating the victim, but also taking measures to identify and prosecute the perpetrators. So there is no reference to the fate and whereabouts of the victim, right? There is the duty to, coming back to Rainer and Luciano's discussion earlier in terms of the search and investigation, the emphasis on investigation, not on the search. Although the court, of course, also admits that this whole process is really constitutes ill treatment for family members. Whereas when you look at the Inter-American Court of Human Rights, you see that the court has been engaging very briefly, but still has been engaging with the right to truth, right? Because this is raised by the applicants, and the court says, although the court says, it is already subsumed in the articles concerning right to fair trial and right to judicial protection, so it doesn't treat it as an autonomous right in a way. It does say that, of course, it has an individual element, and there's an individual right to truth and a collective right to truth. So the individual, meaning, of course, the families, need to know the fate and whereabouts, right? What happened, but also that the collectively society has the right to know that. But the European Court really doesn't get into that discussion.
Okay, thanks very much. We're almost done, I think, but we have one more question from the floor. One of the
Henrietta, I'm sorry if I interrupt, but I think there's also a question from Rainer Huhle and Gabriela, but they cannot sort of put it in the Q&A, so maybe they can come up as speakers and then ask the question directly. Would that be possible?
Yes, absolutely. Please go ahead. I'm sorry, I didn't see them.
No, you couldn't see them. It's a technical issue, but if they come on screen now, I think they can ask their question.
Very good.
Okay, thank you so much. And Gabriela is also coming. Dilek, I wanted to ask a very simple question. There's a proposal right now for a European Convention against enforced disappearance. In the light of your exposition, what do you think?
Rainer, you were disconnected very briefly. In the light of what do I think about whether...
About the proposal for a European Convention against enforced disappearance.
Yeah.
And
well, I mean...
Maybe Gabriela also makes a question so that we are through.
Okay.
Yeah, sorry, my question is rather to Andreas and maybe is a request for clarification, because if I understood correctly, you say if there is no request for information, then there would not be a crime. But what if we have a person who doesn't have family and he or she is subjected to an enforced disappearance? Wouldn't there be a crime after all? Thank you.
Dilek, do you want to start?
Yeah, and I'll also, I think, take the question that was raised, in the Q&A session that you were, Julieta, just mentioning. I'll start with Rainer's question. I mean, of course, the more the better. The more specialized conventions, instruments, the better, especially in the European Court of Human Rights, in Council of Europe context, because the European Court is quite restrained in its approach. Having said, and I mean, we see in the Inter-American Court of Human Rights jurisprudence how the Inter-American Court has actually been making references to the Inter-American Convention on Enforced Disappearances in terms of defining, for example, the enforced disappearance. So that's important. Having said that, I am not sure whether that would change, make things very different for the European Court of Human Rights, because after all, when you look at how the court has pretty much really, I mean, I'm going to say dismissed, but let me soften this language, say not sufficiently taken into account the reports of the Venice Commission, the Council of Europe Commission on Human Rights, of course, the Committee on Torture Against Torture. These are all Council of Europe's bodies. So they're, cousins, let's say, of the European Court. Okay, non-judicial, but still, I'm not sure whether it will change things very much in practice. But of course, very welcome. And the question about it's almost impossible to prove the case beyond any alternative standard. Well, I mean, I think the Inter-American Court of Human Rights presents that standard to us. What they call the reasoned judgment. But what it is, I think, and here I will go back to what Rainer said earlier in his remarks. He said, I'm a political scientist, not a lawyer. But I think that's the kind of interdisciplinary thinking and approach we need at the European Court of Human Rights. And that's precisely what we see, I think, in the Inter-American Court of Human Rights. The European Court is too almost legalistic. They're too lawyerly, although I think there are multiple ways of being, in legal thinking, and you can definitely have a socio-legal approach, and you don't have that. Basically, what the court needs to say is, what is going on here? Just step back and look at everything. Look at the fact-finding reports of UN and Council of Europe bodies were produced by experts who actually went to Turkey, talked to people. That's what the basis is, right? Witness reports, expert testimonies, etc. So step back, look at the picture, look at media reports, look what's going on in this country, and then say, I see a picture here. I see a pattern, because there is a pattern. What happened in Honduras was very similar to what happened in the Kurdish region. And then say, well, then it is really, and then use your logic and reason, right? And this really, what happens to this particular person fits to this profile. And then, the burden is on the state. You prove to me, you tell me what happened and explain this. I think it is possible. It's just they need to think a little bit out of the box. It's not even out of the box because they have the jurisprudence of the Inter-American Court since 1988. So it's not, it's not. They don't have to reinvent the wheel in a way.
Marcus, can we stay 1 extra minute for Andreas to respond to Gabriela?
Oh yes, please.
Thank you. And maybe also just briefly to the Q&A question. I mean, I wouldn't change the standard of proof here in criminal law, because I think that's quite decisive that it's the same for all crimes. It's more about the elements of crimes and how you, what you need to prove. That's relevant here, but not the standard of proof. Gabriela, of course, you quite well spotted one of the quite interesting parts here. I mean, I was referring to German law, where it says, also the Code of Crimes Against International Law in paragraph 7, number 7, it actually said that a refusal to give truthful information upon inquiry, and that's something you don't find in other texts. So I think under German law, if you don't have an inquiry, it doesn't say that it needs to be by family or relatives. It can be probably also by other people, but you need some form of inquiry into the whereabouts or fate of a disappeared person. So I think that's a relevant element here, which you don't find necessarily in similar definitions or conventions. So it's quite interesting, of course, to compare the different laws, and that's certainly one element here. It's interesting to compare.
Thank you very much, Andreas and Dilek. And because we're already a little bit over, I'm just going to hand over to Marcus with the panel's thanks.